Thank you for the technical assistance. Just gonna set my alarm. So, hello everybody. My name is Michael Conrad. I'm a counsel at Clyde Co office in Paris, and I'm most of my time is dedicated to working on construction projects, mostly on the dispute side, whether through arbitration or state courts. And as such, I've been asked to discuss a little bit about the concept of liquidated damages in France. So that's what I'm going to try to do within the next 10 minutes. So if we could switch to the next slide, please. Okay, thank you. So, first of all, I think it's important that we tackle the issue of the notion itself of LDs under French law, because it is not as quite clear-cut as it may seem. As you, one of your presidents referred in the introduction of this conference, the concept of LDs is universal, obviously. Everybody knows what LDs are aimed at. You know, it's generally a fixed or determined sum agreed upon by the parties to a contract to be payable in case of a breach without the need to proceed to the courts to assess the damages payable for the breach. So the concept is universal, and of course it is well accepted in France, notably in the construction sector. However, and this is really something that we should stress, there is a major difference of approach between common law countries, where the concept originated and where it is very well developed, and the French civil law approach. I'm going to try to explain very quickly the difference. So basically, in common law, LDs are supposed to be a genuine pre-estimate of the loss suffered by a party, which means that the parties need to be very careful when they draft liquidated damages clauses, because the risk, if they do not do so, is that a court or a tribunal may qualify these clauses as penalty clauses, which we all know are not enforceable under common law. For example, parties should avoid stipulating rates of LDs that could be perceived as penalizing for the contractor for late completion. So this is very roughly described the common law approach. So LDs are something different than penalty clause. Now, in France, it is totally different. We have the notion of penalty clauses, clause pénale, that is enshrined in the civil code. And actually, he's been enshrined in civil code since the very beginning of the civil code, the French civil code drafted by Napoleon, as you all know, in 1804. And the basic concept that you should grasp is that penalty clauses under French law are clauses which aim at deterring a party from failing to perform its obligation. And how do we do so? We set out an excessive monetary sum unrelated to the actual harm against the defaulting party. So you can see the total difference of approach. We allow, through penalty clauses, that parties set an excessive monetary sum. So it's not a genuine pre-estimate, it's an excessive monetary sum, which is not related to the actual harm suffered by one party. So we're miles or a universe away from what is generally admitted under common law. And I think that when you, at least when you get interested in French law, but I would assume some of the other civil jurisdictions are the same, I think you need to be careful when working along the concept of LDs. Yes, we know LDs, we know the concept, but it isn't managed at all in the same way than our friends in common law countries. So that was my first slide on the very notion of liquidated damages. Now, if we can move to the next slide, please. Thank you. So now a bit about the regime of penalty clauses in the French law. So we, as I mentioned earlier, we have a legal basis to provide for penalty clauses in contracts. It is the Civil Code. As I mentioned, you have an article 1231.5 of the Civil Code, which provides that where a contract stipulates that the person who fails to perform shall pay a certain sum of money by way of damages, the other party may be awarded neither a higher nor a lower sum. So you get the idea from this sort of definition. The penalty clauses sets a fixed amount that will be paid should the contractor be late in the completion of the project. One interesting fact is that so in France, we have separate rules applying to private and public projects. We have several courts and several sets of rules, and therefore we do not have the same provision for private projects. We do not have the Civil Code for public projects. However, we have a very widespread use of standard form of contracts, and the main form of contract which is used for public projects is called the CCAG or CCAG. And you have an Article 19 in this standard form, which provides for penalty clauses. So the concept is widespread used, regardless of the nature of the project. Of course, parties are not obliged to insert penalty provisions in their contracts. At the end of the day, the contract is the thing of the parties, so they literally draft a construction contract, as they fit. However, they always, to my experience, I've never seen a construction contract without a penalty clause inserted, either directly with parties who are used to draft bespoke construction contracts, or indirectly by the mere reference to a standard form of contract. And I'll tackle this a little more in my next slide. Importantly, there's a condition precedence to apply penalty clauses in French law. The employer, because it's usually the employer who triggers the penalty clause, will need to send a formal notice to perform before applying the penalty clause. Another important issue is that a simple breach will trigger the penalty clause. In other words, one party or the employer does not need to prove a faulty breach or negligence, nor the existence or the extent to the damage he or she has suffered. So it's rather easily triggered. And finally, what is very typical of French construction proceeding is the widespread use of summary proceedings. We call it référé, to enforce penalty clauses. Because the test is basically that the obligation is not debatable, and as soon as you can pass this test, you can apply for penalty clauses to be liquidated. This is also the case for projects which are subject to arbitration, but in this case, as mentioned under Article 1449 of the Civil Procedure Code, the party who claims penalty clauses will need to prove that there's some sort of urgency. So the slides basically gives you the rough basis, the very basis of the regime of the penalty clause. And I have, 1 minute left to the next slide, which is the final slide. Thank you. So obviously, when we discuss LDs or penalty clauses, the usual question, the $100 question, will be whether there is a limit in the amount of penalties that can be applied in case of delays. Is there a limit under French law? I would tend to say no per se, because in France, the basic principle of contract law is freedom of contract, which is provided for under Article 1102. So parties are free to, at least in theory, to set a very high amount of penalties, but that is only very theoretical, because one very specific trait of French law is that courts can moderate penalties if they are manifestly excessive in their amount, and it's again Article 1231.5 of the Civil Code. The problem we have is that there are no guidelines or rules to determine when exactly a penalty is manifestly excessive. So how do we do it? How do we tackle on this issue? Well, it's very simple. First of all, you should refer to standard form of contracts, which provide a useful reference for what is accepted among the industry. And for example, I've set, like in brackets, the rates of penalties which are provided for by the main standard form of contracts, NFPO 0302 CCAG. So you can see that the rate is, I would say, rather low, 1/3000th of the project value per day, with a cap, a liability cap of 5%. That's I would say the norm for standard construction projects. Obviously, when you negotiate contracts, bespoke contracts, the employers will want and will always increase this rate. So in this case, another set of reference lies in case law, French case law. And this is very interesting because I've put also examples in here of courts admitting the validity of penalty clause of up to 25% of the project value, which is much more, as you can see, than from standard forms of contracts. So it is really on a case-by-case basis, and at the end of the day, there is somehow a proportionality test, basically meaning that penalty clauses will usually be reduced if they are disproportionate when compared to the loss actually suffered by the party claiming the penalties. So in very roughly speaking, French courts can reduce the penalties. However, there is some room here to negotiate and draft a contract. There is no golden standard, no golden rule. And I think, yes, I think I'm done with